Allow me to introduce our speaker for today, Attorney Chrysilla Bautista. Attorney Bautista graduated magna cum laude from the University of the Philippines with a degree in English Studies. She then studied law in the same university and graduated in 2000 and was thereafter admitted to the bar. In 2007, she obtained her Master of Laws degree from Columbia University, where she graduated with honors as a Harlan Fiske Stone Scholar. She also took on a course on private international law at the Hague Academy of International Law and was also admitted to the New York Bar in 2010. Attorney Chrissy is presently a professorial lecturer in the University of the Philippines, teaching courses in criminal procedure and special proceedings. She has also published articles on different topics such as libel, anti-sexual harassment, and reproductive technologies. She has also contributed to the Philippine chapters in international publications on anti-corruption regulation, civil procedure, and securities law. In 2007, she was recognized as among the leaders in their field for both general business law and dispute resolution. She is a member of the UP Women Lawyers Circle and the Association of Attenders and Alumni of the Hague Academy of International Law and the Columbia Alumni Association. Let us all please give a warm welcome to Professor Chrysilla Bautista. Good afternoon, ma'am.
Good afternoon, everyone. So thank you for joining us this afternoon. So I understand that we have an hour so that we could discuss your questions, right? And proposed answers, assuming these questions will be asked in the bar. But I think it's just to give some perspective, no, for us to have, the proper framework. When we review criminal procedure and special proceedings, I will really emphasize that from the questions, from the past bar review questions, for criminal procedure and special proceedings, the answers will always be based on your caudals. So if there is anything that you need to master, for example, you have a limited time, right, between your caudals, your annotations, and your reviewer, I think it should be the caudals which you should prioritize. Okay, so that's number one, caudals. And other than the caudals, you should always refer back to the bar syllabus that has been circulated by the Supreme Court. Because not all provisions will be covered, particularly in special proceedings, right? So I think it's important that you always refer to the bar syllabus. So if the topic that you think you're not comfortable with or you haven't really understood during your law school days, but if it's not in the bar syllabus, then you shouldn't worry about it. Okay? So at least that's one way so that you will not be overwhelmed. Stick to the bar syllabus and stick to the caudals. So if by now you've gone over the videos and if you have access to the slides, I would want to think that the text in those slides, as long as you master them, it will be sufficient for you to answer any bar question in Crim Pro and Spec Pro. Okay? Because all of the topics and all of the pertinent rules and doctrines, right, particularly caudal provisions, have been made part of that PowerPoint presentation and explained in the video. Okay. So let's go through the questions that have been sent prior to today's sessions. So the first question, in a qualified theft committed online, so I understand that to mean as qualified theft and with the use of information communications technology, ICT, so that it will fall under your Cybercrime Prevention Act. The question is, can we consider grave abuse of confidence as an element? So yes, grave abuse of confidence is an element of qualified theft. But the question is, can we consider grave abuse of confidence as an element? Thus, the place where it is committed can be a venue for action. So I think we need to also correct the question, Because when we determine venue, right, we look at the overt act. The element of grave abuse of confidence on its own is not an overt act, but it describes the nature of the act or the nature of the taking. So again, when we look at venue, we look at the place of commission of the offense. And if we want it to fall under the Cybercrime Prevention Act, at any place where any of that ICT is located. So it's not the while grave abuse of confidence is an element of the offense, that in itself cannot be determinative of venue. Because when you talk about elements in determining correct venue, you look at the overt acts. Okay. So it just so happens that in the nature of qualified theft, this element of grave abuse of confidence is intended to characterize the nature of the taking. Can an improvident plea of guilty be withdrawn as a matter of right? Okay. So again, let's also tweak the question. When we talk about withdrawal of an improvident plea, the applicable rule is Section 5, Rule 116, and it states that an improvident plea may be withdrawn at any time before conviction becomes final. If you look at Rule 116, Section 5, there is no mention as to whether it's done as a matter of right, as a matter of discretion. There is no mention whether there is a need for leave of court. So let us just keep the rule simple as stated in our codals, right? Where it says that at any time before judgment of conviction becomes final, the court may permit an improvident plea of guilty to be withdrawn and be substituted by a plea of not guilty. So if you look at the timeline, it means that at any time before the judgment of conviction becomes final, meaning at any time before the lapse of the 15-day period, right? So it can be after conviction, but before it becomes final. That's one. And two, the rules provide, or at least the operative word is may, so meaning it can be withdrawn at any time, right? There is no requirement that it be done with prior leave. It just has to be done by proper motion. So number 3, can the validity of a plea of guilty be challenged? Okay. So when we think about this question, who has the incentive or who among the parties in a criminal case would want to challenge the validity of a plea of guilty? Right? So it will not be the prosecution, right? Because as far as the prosecution is concerned, right, they would rather that the accused enters a plea of guilty to expedite the proceedings and that they could achieve a favorable resolution, right? So if you're the prosecution. So with respect to this question, who will challenge the validity of the plea of guilty, then it will be the accused. So what will be the possible grounds for the accused to challenge that plea of guilty is that one, if it was an improvident plea, so as earlier discussed, it can be withdrawn at any time before a judgment of conviction becomes final. Can it also be challenged for other grounds? Yes. If it was not voluntary, if the substantive requirements to ensure due process and to protect the rights of the accused are not present. For example, if the accused enters a plea of guilty but is not assisted by counsel during arraignment, then that plea of guilty can be set aside. Okay. So what are the other things to remember with respect to entering a plea of guilty? This is the first time that this was included in your bar syllabus. So if you look at your bar syllabus, there is a specific mention of the case of People versus Pagal. This goes into the searching inquiry, the requirements on the part of a judge if there is an accused who wants to enter a plea of guilty. So the requirements in People versus Pagal are actually discussed in the slides and in the video lecture. So just please review that. I think that will be asked in this bar precisely because that specific jurisprudence, that specific ruling was made part of the course syllabus, and that's the first time it was expressly included. In the plea of guilty, are there instances when aggravating and mitigating circumstances were set aside in the conviction of the accused? I think in answering question number 4, we need to review what are the applicable rules. So it is possible that an accused after arraignment enters a plea of guilty, right? He enters a plea of guilty to an information where the aggravating circumstances have already been alleged. Note, however, that if you refer back or you review your requirements on the required contents of a complaint or information, there is no mention there that mitigating circumstances must be alleged. Right? So it will be the qualifying and the aggravating circumstances that are required. So what happens after a plea of guilty is entered by the accused? Then it depends. If the plea of guilty is to a capital offense, right? Capital offense under Section 3 of Rule 116, then the rules provide that the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea. So that's the import of People versus Pagal. And shall require the prosecution to prove his guilt and the precise degree of culpability. The accused may then present evidence in his behalf. So if it is a plea of guilty and it is to a capital offense, then the prosecution is still directed, it's still mandated or required to present evidence to establish the precise degree of culpability of the accused. So as to the question, are there instances when aggravating and mitigating circumstances were set aside? So to answer this question, at least the way I understand it, then the court will rule depending on the evidence presented by the prosecution if the accused entered a plea of guilty to a capital offense. However, if it is a plea of guilty to a non-capital offense, then the reception of evidence is discretionary, the rule you will find under Section 4 of Rule 116. So when the accused pleads guilty to a non-capital offense, the court may receive evidence from the parties to determine the penalty to be imposed. So it depends now on the evidence presented by the parties as to the penalty to be imposed by the court, because the aggravating and mitigating circumstances are relevant with respect to computation of the imposable penalty. In relation to Rule 113, if there is delay in delivery of the persons arrested to the nearest police station, is he criminally liable under Article 125 of the RPC, or is he only administratively liable? Okay. So let's review the rule, right? So this rule is relevant when there is a warrantless arrest. So depending on the imposable penalty for which the accused was arrested without a warrant, then he must be delivered not only to the nearest police station, but the applicable periods under Article 125 refers to the period when the accused must be delivered to judicial authorities. So it's not only commencement of inquest or preliminary investigation, but it's actually the filing of an information if an information will be filed in court. So that's the import of Article 125. Right? So that within those reglementary periods of 18, 24, and 36 hours, the person who's been arrested must be delivered to your judicial authorities. So what will be the possible liability of the arresting officer if there is failure on their part to deliver the a person arrested without a warrant to the judicial authorities as required under Article 125, they can be criminally liable under Article 125 of the RPC, and so cumulatively he or she can also be administratively liable. The next question is for Spec Pro. May a plaintiff file an action for recognition of divorce without the need to file an action for correction of entries? So my answer here is the rule is, right? The rule is apply individual, the concerned party now who seeks to have an entry corrected in the civil registry, that entry can be corrected by filing a petition under Rule 108. So petition for correction of entries. If that entry pertains to the civil status, so that from married, it will be corrected to reflect that that person is now divorced, under the ruling in Fujiki versus Marinay, the Supreme Court said the petition for correction under Rule 108 is sufficient. It's no longer necessary to file a prior action for recognition of a foreign judgment. So that's the controlling rule. I think that was asked in the bar, I think 2 years ago. 7. So I looked this up. I read the case of People versus Comenforte. It's a 2021 decision. So the question here is the rule in prejudicial question that a civil action be filed before a criminal action mandatory? Could there be a prejudicial question if the civil action was filed after the filing of the criminal action? So what is the rule? Okay, so maybe we should first talk about what is provided for on a prejudicial question, diba? So why is prejudicial question important? A prejudicial question is important because it is a ground to cause the suspension of arraignment. So prejudicial question is a proper ground for the suspension of arraignment. So who files it? It's the accused who files it. The definition of prejudicial question, right? You find it in Section 7 of Rule 111. So Section 7, Rule 111 provides the elements. 1, there is a previously instituted civil action that involves an issue similar or intimately related to the issue raised in the subsequent criminal action. And B, the resolution of such issue determines whether or not the criminal action may proceed. So that is what's provided for in your CODAL, Section 7, right, of Rule 111. This is in your 2000 revised rules of civil procedure. It now sets forth a timeline, right? Meaning the civil action should have been filed first, and it's the criminal action that's filed after. However, in the case of People versus Comenforte, what the Supreme Court did was that it traced the origins of the doctrine of prejudicial question, and it said that the rule is not mandatory. Okay. So that's the ruling in People versus Comenforte, where the Supreme Court said that the civil action which gave rise to a prejudicial question need not be filed prior to the criminal action. Clear. But if I were to be asked, and if I were the bar examinee and I will be asked a question on prejudicial question, then I will answer it based on Section 7, right? So what will be my legal basis? 1, it is Section 7, and 2, if these are not the attendant facts, then if you review what are the prohibited motions in your rule on continuous trial, it will also be included there, where the Supreme Court puts emphasis that the civil action should have been filed first and the criminal action after. right? Because by way of background, the rationale for limiting and having a prescribed timeline or sequence of events behind your rule on prejudicial question is that the Supreme Court wanted to discourage creative lawyers from suspending and causing the delay in criminal cases by filing after the fact or belatedly filing civil actions only for the purpose of frustrating the prosecution of a criminal offense. So again, if I will be asked, right, I could either just stick to what's provided for in the codals, which is in Section 7, Rule 111, right? 2, support it based on what are considered prohibited motions under your rule on continuous trial. Or if I have time, I will suggest as an alternative answer, People versus Comenforte, right? But if it were me, I will just keep the answer short and simple and cite the codal provision. Next question. So the next question is on Rule 112, Section 5A. So that will be on preliminary investigation. Okay. Can the judge conduct preliminary investigation? So the answer is no, right? The answer is no. So I think we have to understand the context of that answer. Okay, so I refer you to Section 2 as to who are the officers who are authorized to conduct preliminary investigation. So it says in Section 2, your provincial or city prosecutors and their assistants, their national and regional state prosecutors, and C, other officers as may be authorized by law, with a qualification that their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court in their respective territorial jurisdictions. So if I am asked that question, then my answer will be in Section 2. Okay, so what I'm trying to say here is that we keep the answer simple. So previously, under the old rules, a judge can conduct preliminary examination, which was akin to a preliminary investigation in instances when there is a complaint that is directly filed before it, but that's no longer the prevalent rule. So we answer it based on the current rules. A present judge now in the MTC cannot conduct preliminary investigation. So preliminary investigation, as we understand here in Rule 112, is the phase of the proceedings when there will be an inquiry to determine whether there is probable cause to file an information against the accused in court. So that's defined under Section 1. It's an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that 1, a crime has been committed, and that 2, the respondent is probably guilty thereof and should be held for trial. So next question. In relation to the last paragraph of the above-mentioned provision, what additional pieces of evidence are allowed to be presented by the prosecutor? Okay. So let's again refresh. Okay, let's do a quick review. What is Section 5A? Section 5A talks about the independent determination of a judge, independent personal evaluation of the judge in determining whether there is probable cause to sustain the filing of the information in court, and 2, to issue the warrant of arrest, or if the accused has already been arrested and is in custody, for the issuance of a commitment order. So for purposes of determining probable cause with respect to the filing of the information, to sustain the filing of the information in that court, and for the issuance of a warrant of arrest, 1, there is a requirement for personal determination, but there is no requirement for a personal inquiry or a searching inquiry, no requirement for an evidentiary hearing, no requirement that there be a personal examination of the complainant and the witnesses he may produce. The rules only provide that the personal evaluation of the judge will be limited to the resolution of the prosecutor and the supporting evidence which were submitted during the preliminary investigation. The last sentence of this paragraph says, in case of doubt on the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and the issue must be resolved by the court within 30 days from the filing of the complaint or information. So if you will ask me as to what kinds of evidence may be asked of the prosecutor, it could be any. Right? But I would want to think that the judge will only ask the prosecutor to submit all records presented or filed before it. So I think that's the simple answer to this question, because the prosecutor in our jurisdiction does not take an active role in the investigation of the offense. The prosecutor during preliminary investigation only receives evidence, affidavit, supporting evidence that are submitted before him or her. So if the prosecutor is directed to present additional evidence, it mainly means any other evidence presented before it. The next question, this is for a request for the removal of the middle name for illegitimate request for the removal of the middle name for illegitimate children. Does the action fall under Rule 108 or Rule 103? But if it will be a removal of the name in the, let's say, birth certificate, middle name, I think if it's a middle name, then it also involves the status. I think it can be in Rule 108 because it will also go into the status of the child. Right? Because you will not necessarily, you do not only remove the middle name, but you also, I'm trying to remember how a birth certificate looks like. If there's any indication there as to names of parents and status of the parents. So I would think it's in Rule 108. If we're referring to an entry in a civil register, but definitely because this involves status, and not merely a clerical error, it cannot be under your RA 9048. So in the cases, they were filed jointly. Rule 103 to correct the name and 108 for the corresponding entry. Okay. So with respect to the second question, I think it could either be 103 or 108. Right? But if it's just in the name, there is no mention in your birth certificate or in any other record as to whether legitimate or illegitimate. And if it's just the plain correction of the name or changing the name to drop the middle name, right? Then it should be 103.
Hello, attorney. I'm not, medyo na-confused ako sa question number 2. Hindi po ba yung mga illegitimate children, wala naman silang middle names?
That is also correct, but it may be possible that at the time the birth was registered, they used the middle name of they recorded as a middle name the middle name of the mother, diba? So if you look at it, they will look like their siblings, pero they shouldn't be. So pag illegitimate child and not recognized and you opted, or the mother did not opt to use the surname of the birth father, of the biological father, then strictly there should be no middle name. So I mean, I understand your question, but if what happened here was the child is illegitimate, not recognized, neither the child nor the mother wants that the last name of the biological father be used as a surname, then the child should not have a middle name. But if initially a middle name was registered, right, which is actually wrong, the question is, can it be changed? Can it be corrected? Then my answer, yes, it should be corrected. It should be changed. Because it's substantial in nature, then it should be Rule 103.
Also, the question revolves around the question is about the mother used the surname of the father, which shouldn't be the case. So parang magkakaroon ng magiging illegitimate, using the father's surname is actually, especially if you're illegitimate without the permission of the father. Dalawa kasi attorney yung law, di ba? Recently, ang law yata ngayon, pwede nang gamitin ng bata ang surname of the father with the consent of the father. Before, wala bawal. Tama po ba?
I think so. But again, di ba? Again, remember, this is the bar, and if the question is as plain as this, meaning can the middle name be corrected, right? Then it can be corrected under Rule 103. My logic here is, if the name, particularly the surname, diba, of a child can be changed because of legitimation, meaning from illegitimate becomes legitimate, can be changed under Rule 103, then necessarily the correction in the reverse should also be allowed.
Ma'am Chrissy, I guess while we wait for questions, assuming yung iba po nagta-type pa, maybe if you have some pointers or tips for them while they study so that they could do some focused reading perhaps, or tips maybe on how to answer if they're being asked in the bar exam.
Okay. So with respect to the coverage of criminal procedure and special proceedings, my suggestion is you always stick to the bar syllabus, right? Because I think, when we read on our own, diba, and we study on our own, we have the tendency to overthink, to read more than what we should, right? I think at this point, we should already be at the level where we can already recite aloud or write for helping us recall concepts. For example, what I would do is I will look at the bar syllabus, right? I will look at the bar syllabus. Then, for example, in criminal procedure, it says here, general concepts, criminal jurisdiction, concept and requisites for exercise. On my own, I should be already able to recite those doctrines. When injunction may be filed, I already know that the general rule, criminal prosecution cannot be enjoined, right? And I can already recite the exceptions. So that's how I will test myself, right? Other than going over sample questions and suggested answers. But by looking at the bar syllabus, I should already be able to give the definition, state the rule. That's how I would do a review, right? So if it is a topic or a subtopic that's not mentioned here, then I will not worry myself about it. For example, it's very pointed, which I think is the good innovation of the bar through the years, is that they really give a specific syllabus. They even give you the subtopic. So for example, when the bar examiner said, the rule on cybercrime warrants, section 2 only, it's only section 2. Whereas in the past, they did not limit it to section 2. Right? So it already hints to us that if there will be questions on this topic, it will just be limited to section 2. So as to review, the idea is not to read different materials, right? But it's only to read the same material over and over again to improve retention and mastery. That's one. And number two, with respect to answering questions, there are only at least 2 types of questions. A question that will ask you for the rule. It will ask you to define, it will ask you to state, it will ask you to compare and contrast. So those are typical objective codal questions. The other kind of question will be, you will be given certain facts, and then you will be asked a question or two questions based on those facts. So those questions with a fact pattern, right? Do not be overwhelmed with the narration because the answer will still be based on your caudals. So what you do is, if you think you're overwhelmed by the narration, read first the question, right? So that when you read the facts, you know what to look for. When you read the facts, it's guided. So that's how I will do it. And I will just answer based on the caudal provisions. If I know for sure the section number and the rule number, then I'll cite it. But if not, then I will just say under the rules of court. Or based on jurisprudence, if I cannot state the case. I would rather state it broadly and cite the correct rule than citing the wrong case. So those are my bar tips to keep it simple. Diba? So I always tell myself, even up to now, even up to practice, it's to think clearly, write clearly. Because if I cannot think clearly, then I will panic and I will just put fluff in my answer, which will not merit any points. So think clearly, write clearly. If verbatimly you can cite the code, good. But if not, make sure to still state it correctly. You will still get points. So stick to the caudals. So maybe, Jel, as a last tip, if during the bar, diba, you have limited time, during the day of the bar, the morning of the bar, while you're having breakfast, between bar tips and caudals, what will you read? Tips. Kayo, babasa kayo ng tips. Diba? Suggestion ko, basa kayo ng caudals. Caudals pa rin. Kasi yung tips, hindi mo alam saan galing eh. Right? So between tips and caudals. Between study breaks, when you change, parang you shift from one subject to another. Right? When you're still trying to get settled. Diba? To prepare yourself for another 4-hour quiet reading. Diba? If you want to take a break, always have your caudals.
Good afternoon, attorney. Attorney, may question lang po. If the rules on summary procedure with regards to criminal cases, is it also good if we also toggle that in our review?
It's not kasi in the syllabus eh. Unless it's in the part of what I have here with me will just be the syllabus for Spec Pro and Crim Pro, unless there's a part in remedial law where it's a syllabus on like the different courts, hierarchy of courts, because that's already amended, diba? There's already a rule applicable to first level courts. But if it's not in the bar syllabus, then there's no need to include it. But if you will ask me, the rules specific to the MTC for criminal cases, then it's not here, then we do not include it.
I think there are no more questions from our group. And with that, we'll say thank you very much to Prof. Chrysilla Bautista for your valuable insights. We definitely appreciate your time and your effort to respond to our reviewees' questions and give us tips on how to review and how to answer for the bar. Maraming salamat po, ma'am.
Thank you. Good luck.